This is Giovanni Di Stefano for Studio Legale Internazionale. Now, today is the 18th of October 2007, and nearly 100 years ago, in 1910, a man called Dr. Crippen stood trial at the Central Criminal Court in London, commonly known as the Old Bailey, for the murder of his wife. In fact, I want to read to you the actual indictment that he faced. And it goes like this. For that you did, at 39 Hilldrop Crescent, feloniously and wilfully, and with malice aforethought, kill and murder one Cora Crippen, otherwise Belle Elmore. The judge at the trial was the Lord Chief Justice himself, and he tried the case. Mr. R.D. Muir was the prosecuting counsel, and Mr. Tobin, not quite the Marshall Hall of those days, was the defence counsel. Crippen was convicted of the murder of his wife, notwithstanding that the body was without recognition, and that the only evidence was that of a young pathologist called Dr. Bernard Spilsbury. Now, English history, judicial history, would hear much of Dr. Spilsbury, and he's a man that has been causing me some considerable concern in some of the research that I do from time to time. Now, I've been looking into the cases of Dr. Spilsbury for more than 3 years. He was, for example, involved in the Brides in the Bath, in Major Armstrong, the Brighton trunk murders. But in 1947, he killed himself, probably because 2 of his children died during the Second World War. In fact, it was the Attorney General, Lord Goldsmith himself, who in January started highlighting the problems of expert witnesses who refuse to say, I may be wrong. And it was the arrogance of office of Dr. Spilsbury that convicted Dr. Crippen, even though the very last words that Crippen said, I am entirely innocent of these charges. Now, one of the important things in English law is that if you are accused of murder, it is a specific person. Of course, if that person isn't the person who you killed, you cannot obviously be guilty of murdering Mrs. A if Mrs. A is not Mrs. A. If it is another person. Now, you may be guilty of another murder, but you cannot be hung, of course, for murdering a person who specifically is not that person. Now, in 1910, we didn't have, say we, I wasn't around at the time, although sometimes I feel that I'm even older than Methuselah, didn't have the sophisticated DNA that we have today. And thanks to a doctor, a forensic scientist in Michigan, Dr. Trestrow, he's carried out research over the past 7 years. He's traced the relatives of Dora, and he has found that the DNA simply does not match. And here's how he's done it. Come close. Let me show you the chart here. This is the DNA project chart, but more important, it's this slide. This is the slide of the appendix tissue which Dora supposedly had. And based upon that there, they were able to test the relatives of Dora and found that it didn't fit. So if the DNA doesn't fit, you can't convict. Well, they, of course, were the words of Johnny Cochran in the O.J. Simpson trial. If the glove don't fit, you can't convict. But in the case of Crippen, he was convicted and he was duly hung. There's also the question of the conduct of Sir Winston Churchil, who was then the Home Secretary. Now, a letter on the 25th of October 1910 arrived at Pentonville Prison, Well, that letter was supposedly came from the wife that he had supposedly killed, the one that was part of the body in the house there. Well, I'm sorry to say that Sir Winston Churchil and the governor of the prison certainly committed an offence under the then Prison Act, Article 95, because they interfered with a potential point of appeal. Because if the appellate lawyers of Dr. Crippen had the letter, had it tested, and had it verified, and if Dora were alive, then of course he could not be guilty of murder. Now it's ironic that exactly to the date when his trial started, I am pleased to say that I filed an application for a posthumous pardon. They won't do Dr. Crippen any good because he's been dead many, many years, and he would have been dead anyway even if he hadn't been hung. But it's important that justice must not only be done, but it must be seen to be done. And I'm looking for the Secretary of State and Her Majesty the Queen to grant this pardon, because this man was erroneously convicted. The conviction is unsafe. It is unsatisfactory. It wasn't the woman there. He did not kill his wife. And therefore, he should be posthumously pardoned.